Is it ever appropriate for an attorney to make promises to a jury during the middle of your trial? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So let's say you brought a lawsuit against your doctor claiming that he was careless, causing you significant harm and injury. You brought a lawsuit for medical malpractice. And now the doctor turns around and says, I did nothing wrong here. And if I did something wrong, guess what? I didn't cause you any harm or injury. And then he says, you know what? If I did something wrong and I caused you harm, your injuries really are not as bad as you claim them to be. And then he says, you know what? We're never going to settle this case. I'm never going to negotiate. I'll see you at trial. That means 2 or 3 years down the road, your case gets to trial. So now here's the question I raised in the title of this video. Is it ever appropriate for an attorney to make promises to the jury? And I'm not talking about making a promise that, hey, if you vote in my favor, I'll give you something of value. No, that's bribery. That cannot happen. That's unethical, and the attorney will lose his license if he does that. I'm not talking about bribing a juror. I'm not talking about witness tampering. I'm not talking about jury tampering. I'm talking about making promises to the jury during the course of your trial. And the answer is, yes, it is appropriate. So what am I talking about? So now at the very beginning of the case, your attorney gets up to give opening argument to the jury. And during that time, he's going to make certain promises. He's going to say, ladies and gentlemen, during the course of this trial, you are going to hear certain witnesses testify. And we are going to show to you that we are more likely right than wrong, that number one, this doctor was careless. And number two, that this doctor's carelessness was a cause of this patient's injuries. And number three, that the patient's injuries are in fact significant and permanent. We're going to show that to you. Now what does that mean? Well, those are really promises. So that now, during the course of trial, I'm going to put on various witnesses to show and to prove to the jury that we are slightly more likely right than wrong, that what we are claiming is true. So I will be putting on medical experts, I'll be putting on other witnesses to go ahead and support the claim that we're bringing. And now at the very end of the trial, I'm going to ask the jury to go back in time to when we first started and say something like, ladies and gentlemen, at the very beginning of this case, I made certain promises to you. I promised that we would show you that this doctor was careless. And look at this, we brought in Dr. Jones to come in here and testify to explain why and how this doctor was careless. I lived up to my promise. And I also promised you at the very beginning of this case that we were going to show to you that we were more likely right than wrong, that the doctor's carelessness was a cause of this patient's injuries. And I brought in Dr. Gold to go ahead and explain to you why that occurred. And then I promised that we would show you that this patient's injuries are in fact significant and permanent. And we brought in all of these doctors and the patient herself to go ahead and show you that this patient's injuries are in fact permanent and she is disabled from doing her daily activities. I lived up to my promises. And now let's contrast that with what the defense promised you. Because typically each attorney is going to promise that they'll show something during the course of trial. You don't have to make those promises, but you will find that some of the best trial attorneys in New York actually go ahead and say, ladies and gentlemen, we are going to show to you during the course of this trial the following things. And at the very end of the case, I'm going to come back to you and ask you for a verdict in our favor. Why? Because I lived up to my promise, that I showed you that we are more likely right than wrong, that this doctor violated the basic standards of medical care, causing this patient significant harm and injury. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these cases every day. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if you have not yet started a lawsuit and have questions about your matter that happened here in New York, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a great day.